Thank you for coming. We have your testimony in front of us. Thank you.
On behalf of the members of the Forensic Division of the Connecticut Psychological Association, we're pleased to be here to provide input to this task force. These remarks are a much abbreviated version of what we submitted earlier for consideration. And with permission of the task force, we would like to combine our time to 6 minutes. Thank you. My name is Dr. Mary Cheyne. I'm a clinical and forensic psychologist who has practiced for 14 years conducting divorce custody and child protection evaluations. My colleague, Dr. Stephanie Lyda, has practiced for 10 years, primarily doing evaluations in the child protection and custody arenas. First, I would like to say that we know divorce is painful and confusing for parents and children. There are many difficult decisions that have to be made. The reason it's important to have individuals from the Forensic Division talk to you today is because ongoing developments in the science and practice of psychology are highly applicable to the problems of how best to help children and parents in divorcing families and divorced families. Between the two of us, we have worked with many GALs and judges. We have found them, by and large, motivated by a genuine desire to help families in crisis, especially children. The families Stephanie and I see are the most high-conflict families in the state, with problems labeled as irreconcilable. These parents are unable to co-parent and to place their children's needs first without involving the court system to a ridiculous degree. The Forensic Division embraces change and progress. We are encouraged that the members of this task force are motivated to make the system better and more efficient with the goal of keeping all our kids healthy.
I would like to start with a small story. I have a friend who is a judge in another state. Before that, she was a GAL, providing free services to children and their families. When she became a judge, she told me her faith in humanity was reborn because the great majority of those who come before the bench are not high conflict and do not require the services of a GAL. The majority of custody issues that come before our court, nearly 90%, do not need a GAL and are settled relatively easily. The cases that our system describes as high conflict do not fit easily into one category, but contain a web of personalities, complex history, and intolerance that are not seen in the rest of the population. The research is clear. High conflict divorce inflicts tremendous damage on children. I speak for the Forensic Division when I say that we would be thrilled if there was no such thing as high conflict custody cases, if the parents would place their children's needs first. Unfortunately, that is not the case, and here we sit in front of you today.
It's our understanding that there are 3 major areas of possible reforms that have been identified in the charge that the legislature has given your task force. These are the reform of the GAL system, the idea of shared custody, and court-enforced parenting time, which is related to the ever-popular yet often misunderstood idea of alienation. The first issue is the reform of the GAL system. Traditionally in Connecticut, GALs have been attorneys, but this is not the case in other states. We hope the task force will recognize the role non-attorney GALs can provide. Having a deeper pool of talent that reflects the fact patterns of individual families will lead to choosing GALs that are best suited for each family.
Doctors, I apologize, but we do have the 3-minute time limit, and I know, but we don't have both people. We don't have both people signed up.
We are both, aren't we?
We were both signed up.
We are both signed up. No?
The woman who signed us up took both our names.
Perhaps we could refer to your written testimony, and you could submit further if you wanted and open it up to questions from the task force. We only have one person signed up. I apologize. We do have a lot of people waiting. Oh, actually, I'm sorry. It does say it at the end of the line. You are both there, so go ahead.
We get 3 more? Fabulous. The second matter is the issue of presumptive shared custody. The phrase shared custody is confusing because Connecticut already has a presumption of joint custody. Neither word is really defined clearly. We ask you to separate the issues of joint custody making and equal parenting time because the 2 issues are different. The idea that every family should have a 50-50 parenting schedule is just as wrong as the old-fashioned presumptions that dads only need to see their kids 2 Saturdays a month. A legal presumption with respect to parenting time that is not tailored to the special circumstances of each family is problematic. So we ask for flexible recommendations that allow each family to have a plan that meet their individual needs, rather than sweeping one-size-fit-all plans.
The third matter is the idea of court-enforced parenting time. This is clearly an effort to avoid what is referred to as alienation. These are some of the most tragic and problematic divorce and post-divorce situations for children. The psychological research is abundantly clear. Not only do children of high-conflict divorce do poorly, children in alienation-type situations do the most poorly of all. It is the opinion of members of the Forensic Division that alienation occurs less often than is claimed. When it does happen, it's less likely the result of malicious intent and more likely to be the result of anxiety on the part of one parent, which is then spread to the child. We urge the task force and judicial to examine each case independently, to understand there is no one-size-fits-all solution, and to engage the services of a professional who understands modern alienation theory to assist them in this endeavor. However, if true alienation is found to exist, where a child has an unreasonable refusal to see one parent, the court must have some ability to enforce orders. This could include financial penalty, incarceration, or in the most serious cases, possibility of custody switching. So the take-home points today are: number one, GALs should come from many different areas of practice according to the fact patterns of each case, but all need to be knowledgeable in issues of high-conflict divorce, its process, and the effects on children. Number two, the issue of shared custody, while often a salve for the parents, often fails to focus on meeting the kid's best interest. It's important to look at each family's needs and capabilities, and also to separate the issues of physical custody, parenting time, and decision-making. Number three, alienation is a real and awful thing. However, using alienation as a tool to batter the other parent or to explain away the effect of pre-divorce poor attachment or bad co-parenting is not only unacceptable, but damaging to children. If the specter of alienation is raised, the court must look at each family separately and utilize the skills of a trained professional who understands current alienation theory to help clarify the situation. Sanctions should only be taken when it's clear one parent is deliberately hindering the relationship of the other parent with the children.
Thank you very much. Are there any questions from the task force for the doctors? Mr. Weissmuller.
Good morning. Thank you very much for that fine testimony. It's very concise and right on the point. I did have a question for you, though. When you talk about the one-size-fits-all, I'm not sure that I've seen that in a recommendation that there be a mandate of 50-50 time. I believe the word presumption talks about a general circumstance that might take place in a limited contest. So I'm not sure if you're seeing the same thing I'm seeing based on the input. Would it be harmful to have a presumption that things would be roughly equal, depending on logistics and circumstances, unless there was a basis to veer from the presumption, as opposed to right now where there doesn't seem to be direction? And if there is a presumption, it's for a primary caregiver, because that's actually contained in the child support guidelines. Once you determine the primary, then many things follow. So there is a presumption in the current paradigm. Would it be harmful, given the fact that I know you were working on high conflict, so I'm not necessarily speaking to high conflict. There are very few answers there. I understand that. But in the less conflicted cases, where there's more opportunity for middle ground, what would it hurt to have a presumption that it's going to be roughly starting at equal and moving away from that, as opposed to where right now people don't know what they're getting, and there seems to be more fear associated with that, fear of loss of a relationship that seems to create more conflict. We've heard a lot about that. Could you answer that, please?
Certainly, there's two parts. First of all, the idea of a roughly shared parenting plan is in the children's best interests, as long as it's phrased in a way that places the children's best interests over that of the parents. At times it seems the wish to do everything 50-50 is motivated more by a parent's need to feel that they have an equal half. The other part is, of course, the developmental part, where parenting plans need to change and adapt based on the children's developmental stages. So those would be the two caveats.
Okay, and on that point, and I've had the opportunity, obviously, to see your work product and so on, and I do appreciate it very much. Do you feel that if you, those caveats you mentioned, do you feel that it would have any kind of an impact, understanding that it might be nearer to 50-50 with those caveats? Would that disarm some of the conflict that you see outside of the very extreme cases, do you believe, based on your experience?
Unfortunately, my experience is with the most high conflict situations in which traditionally both parties believe that the other party should have as little parenting time as possible, and the parents themselves are not happy with a shared parenting arrangement. So perhaps my experience is less useful when it comes to the general population, but in the general population, parents who are able to co-parent and are willing to share their children, that would be the research certainly indicates that is the best possible outcome for the children.
Thank you very much.
Madam Chairman, thank you both for coming. I heard you say that your best result would be really not to be in business and not to be doing custody evaluations and to not have high conflict parents. So I'm just wondering about, I wanted your input as to what resources might help parents so that they would not need your services, as good as they may be. So maybe you can speak to what you see and what you think, what kinds of interventions might be helpful to prevent high conflict parents from getting to that point.
Certainly. I'll start out by saying, again, and emphasizing as much as I can the fact that the children who do the best in divorce are the children whose parents cooperate with each other and put their children's needs first. As soon as you start to introduce conflict, it's a difficulty for the children developmentally, emotionally, etc. There are services out there in terms of mediation services that allow parents to meet on a neutral ground and to discuss reasonably what can and should be done. Very often, if a parent is in an individual therapy situation, they may get coaching from their therapist of, look, this is the parenting information you need to know about your child. Let me tell you what good parenting is all about. If a child is in therapy, the child's therapist can give some input on that. There are a number of services throughout the state that try to help families resolve issues peacefully, as in the Peace Program.
Well, thank you for mentioning that. Do you think, though, that there are enough resources available for parents at this time? It's been a discussion of the task force as to what we can provide for people and the frustration that people have in being able to find these resources and afford these resources.
Certainly, a good portion of my practice is focused on working with low-income population. And as always, there are not enough services for those people without a lot of money. If you have a lot of money, you are capable of buying a parent coordinator or a co-parent therapist, most of which would not be covered under any insurance. So for those people who do not have enough money, I feel there are not enough resources. Another factor to consider too are whether or not the attorneys are of a more conciliatory mindset, or if they are more of a combative mindset.
Thank you both.
Mr. Weismuller?
When it comes to the contest, understanding that you work mostly with low-income people, would a fast track harm or hurt you? And if you don't understand what I mean by fast track, tell me.
Please explain.
In some communities, in some courts, they try every case if they can within 9 months, and they use pretrial orders to limit the contested issues by basically forcing the parties to come in and make sure everyone understands what the contest is about. If it's fully contested, fast track has, usually you're extending it for those cases. So in your case, with the high conflict cases, you probably wouldn't fit into it. But I guess this goes along the lines of if you have someone who has resources on one side and they're deciding to be create a highly volatile litigation paradigm because they have a very aggressive attorney and they're really working it. Are you equipped to respond to it? And B, would a fast track would it limit that opportunity if you tried to condense cases? Or would that not be something you could respond to given your resources?
This is something that some of the members of the Forensic Division have discussed, and we do see it being very uneven when the fiscal resources are not matched between the parties as far as continued litigation. I don't think we have come to a conclusion. The idea of a fast track is very appealing. However, it is also true that emotions tend to be the highest within 6 months to a year following a split, and people are at times more reasonable when things have settled down. Mary?
What I was going to say is that what you need to keep in the mindset is the fact that when the parents are going through the divorce, so are the children, and the longer the time that these children are in a state of not knowing what's going to happen, not knowing what the outcome is. So that's the appealing part of a fast track as a psychologist.
Thank you. And thank you very much both for your time.